Hi, Nancy Beauvair here with Agape and NEXsteps. This year in 2025, Ontario has made some big probate reforms. Now you might be saying, I don't live in Ontario. Why would I care about that? Well, a lot of times what happens is when these legislative changes happen in one jurisdiction, other jurisdictions take notice. They find out if they're more efficient, how they can streamline the process, and how they can better move things forward. For instance, I did an article and a video a little while ago about how Alberta allows for digital applications for grant of probate. And those are being observed in other jurisdictions, and I wouldn't be surprised if what other jurisdictions don't take a look at that and how it streamlines the process and take a look at adopting those as well. So we should pay attention because these things can matter. Now, some of these changes that Ontario is making already are in effect in some other jurisdictions, most notably in most cases in Alberta and British Columbia. But these are reminders. They're not just changing laws and changing paper. They're a real reminder about why you need to update your will and your estate plan on a regular basis, keeping in touch with what legislative changes, what tax laws have changed, and your own evolving life circumstances that may have changed since you last created your documents. So one of the biggest changes that's happening is that Ontario is now allowing for a digital access. You can now have your wills witnessed and signed virtually. Now, there are some stipulations around that just to ensure that they are current. There are things you do need. At least one of the witnesses does have to be an Ontario lawyer or paralegal. There are some little nuances around that. But the fact is that this is going to be very helpful for people who are living in very remote communities and have difficulty with mobility, for instance, and can't necessarily access witnesses that easily. So that's one of the big changes, and hopefully that is something that other jurisdictions will take a look at. Another big change with Ontario's probate reforms is that marriage no longer automatically revokes a will. Now, this is one of those legislative changes that has already been in effect in Alberta and British Columbia, but Ontario has typically had a will be revoked as being valid if a marriage was dissolved. Prior wills to marriage, unless the will was made in contemplation of marriage, were deemed to be null and void. And the result of that is that a lot of people ended up dying intestate because what they thought was a valid and legal will no longer was because they got married. That no longer is the case. However, that's a bit of a double-edged sword because once you get married, your circumstances have changed, and perhaps the way that you want to outline your will and your beneficiaries has also changed. So although it's good that you're not going to die intestate, if you don't update your will, at least take this as an opportunity and a reminder to go out there and update your documents anyway. Now that brings up the question about what happens if you separate. Well, those laws have changed as well, because what would happen before is that under Ontario law, the rules of succession still included those separated, those estranged spouses if someone died and hadn't changed their will. Now that is no longer the case. If you've been separated for at least 3 years or have a formal separation agreement, now that separated spouse will be treated as though there was a divorce in place and will no longer automatically be deemed as a recipient under succession laws, which means that now that person isn't automatically entitled to receive part of your inheritance. Another big change is that the courts now have greater latitude in interpreting the validity of a will. Before, there were very, very strict guidelines, and if you didn't have witnesses signed properly or appropriately, or you didn't have a witness, or perhaps there was a will that was a holographic will, but it wasn't a true holographic will, because under the holographic will definition, it should be completely handwritten. But if you had typed part of it and handwritten some of it, it could be invalidated. Well, now the court has greater latitude. If they're clear that the intention was what you had intended, they have the latitude to validate that will and note it as a legal and binding will. Again, although this does open the door for a little bit of latitude on the production of a will, it doesn't mean that you shouldn't take pains to make sure that your will is properly done and properly verified. Otherwise, it does end up in the courts. It can take time, it could cost money, and it can tie things up for your beneficiaries. So it just makes sense to make sure that when you are doing your documents and you are doing your will, that you do it right the first time. And then as you update it, make sure that it continues to be done correctly. So again, to reiterate, these are changes that have taken place this year in Ontario. And how that impacts other people is perhaps not directly. Perhaps you're not a resident of Ontario and it's not going to impact you directly, but it may influence policy and legislation in other jurisdictions that can help streamline the process. That's why it's important to keep up with these things that change across jurisdictions, because there are implications, there are benefits to following through. But even more important than that, it does serve as a reminder that it is important to review your documents and to make sure that they are up to date based on your current circumstances, your family's circumstances, legislative changes, and tax laws. If you want some assistance with this, I'm a certified executor advisor. I can help you with your planning. I can also assist with estate administration. I invite you to reach out and we can have a consultation and let's see how I can help you. Hop on over to my website. I've got an article that goes into more detail about these changes, and I look forward to seeing you again next time. Thanks for joining me. Bye for now.